Constitution is certainly being tested these days.
The Dan York State of Mind program is brought to you in part by Lookout Rhode Island and Takeo Comfort Solutions.
So tonight's guest is Corey Brettschneider from Brown University, who's a really, really smart guy. Enjoy having him on. He's got no fear in terms of his commentary, and he's written a book on the Constitution. And make a note, we're going to have him this evening to talk about the contemporary news issues that we're facing this week. And then next week, we're going to have a longer conversation about his new book, which is called The Oath and the Office. And while I haven't had a chance to read it because I just got it, I did peek through it. And even in the opening premise, and even on the cover, there are questions and issues that are raised which could take 10 shows. So I'm guessing the book, and the first few pages are really fast reads, so I'm looking forward to devouring this thing over the next couple of days, because I think it's important for us to know the Constitution. Now, some people carry the Constitution around in their briefcase or their back pocket. I carry a golf rules book. I don't, but I think I probably got to grab a Constitution. Or maybe I'll just carry Corey's book around, which is a little bulkier than the hand pocket Constitution. We'll introduce Corey in just a second. Let me remind you that this is Wednesday, but we recorded this program yesterday. So we've had some production scheduling issues. So this program is, if something crazy has happened between yesterday and early afternoon and tonight regarding those particular matters that are reportedly going to climax tomorrow, which is a hearing on Judge Kavanaugh and a meeting for Rod Rosenstein, sorry. But I'm hoping that the president's busy enough at the United Nations to kind of just chill until tomorrow's really big day. So at press time, here was the headline on Kavanaugh, and it was the night before, on Monday, that Fox News ran an interview with him, which I thought was just extraordinarily weird. Let's run that story.
No, I've never sexually assaulted anyone, not in high school. Not ever.
Last night, Brett Kavanaugh went on Fox News and made a rare public statement for a Supreme Court nominee. He defended himself against sexual misconduct allegations.
And I'm not going to let false accusations drive me out of this process.
Christine Blasey Ford says Kavanaugh held her down and groped her in high school. Both of them are slated to go before the Senate on Thursday.
I am not questioning and have not questioned that perhaps Dr. Ford at some point in her life was sexually assaulted by someone in some place. But what I know is I've never sexually assaulted anyone.
Kavanaugh spoke out one day after the New Yorker magazine published a claim by a second woman, Deborah Ramirez. She says he exposed himself to her during a drinking game at a party when they were both freshmen at Yale University.
In my opinion, it's totally political. It is totally political.
President Trump seemed to dismiss the allegations against Kavanaugh. On Capitol Hill and at Yale Law School, Democratic senators joined protesters to demand an FBI investigation.
Anyone going through this process, I would expect to go through a fair and impartial confirmation hearing, and that's not what's happening.
GOP leaders are promising a quick vote on Kavanaugh after Thursday's hearing.
I gotta tell you, I've never seen, well, I don't know how many superlatives and never seens I've mentioned in the last year and a half, 2 years. But this week, I'm having trouble computing the continued tribalism response to this particular matter, that everybody's just kind of fitting their logic into the place where they want to be, as opposed to taking a look at this thing from a, ground zero point of view. Welcome, Professor.
Thank you.
Good to see you.
Pleasure to be here.
Corey just popped up from Morning Joe on MSNBC, so you're popping around with your book, and we're going to take a long look at this for our next taping, which will be for next week. But let's weave that the constitutional issues in and out of this whole thing. First, what is your take on just the Kavanaugh situation right now? in general?
It certainly does connect, and it's an easy weave because a lot of the book is about executive power. And the first, I guess, concern that I have about this nominee is his view about what a president can and cannot do. And I wrote a piece before the hearings called Kavanaugh's Radical View of Executive Power that was entered into the record by Senator Coons. And what I say there is it's very troubling that when he was working for Ken Starr and essentially prosecuting a president or looking into the possibility of prosecution, he seemed to have very serious views about the limits on presidential power. And then that changes radically when he begins to work in the Bush administration and later on, where he talks about a president possibly being immune from indictment and even flirts with the possibility that United States versus Nixon, one of the most important cases in Supreme Court history, was wrongly decided. That was a case about Nixon, the requirement that 8-0, the Supreme Court ruled that Nixon could not be immune or not cite presidential privilege to keep information away from a special prosecutor. It's the cornerstone of the limit on presidential power, and it stands for the idea that no president is above the law.
Well, I'm relieved that your overview answer is on that stuff, because in lieu of the drama that we're experiencing right now this week, that's the real fertile and proper ground for American debate. Meaning interpretation of the Constitution, how somebody moves from one philosophy to another or adjusts, and you're a student of that and a professor of that, and I would like to talk more about that. So why don't we park the tabloid stuff for a second and dig more into that. What do you think moved him from one place to another? Is there a cause and effect, or is this a natural evolvement that just happened with time and the wind?
Well, my worry is that this isn't a judge with a kind of consistent view of the Constitution, and that really he's catering to the role that he's playing. And that's a worrying thing about a judge. If he's prosecuting a president and he has one constitutional view, and then he's working for a president and he has another. You know, I watched the hearings, and he was asked about my article, and I can tell you what he said in response. He said that U.S. versus Nixon is one of the 4 greatest decisions that ever happened. Now that sounds like a robust defense, except when you listen carefully to what he was saying, and when you read his own supposed defense of that case, for instance, in a Georgetown Law Review article, what he's really doing is narrowing the case. It turns out that what he thinks was terrific about it was that it applied in that particular circumstance with all the extenuating circumstances that were happening during Watergate, and my fear is that it would never happen again, those circumstances. So that is a case that was for one place, one time.
Well, what was the nature of the circumstances that were so unique?
There are a few things. For instance, he refuses to answer the question when our own terrific questions by Senator Whitehouse about, excuse me, about whether or not this circumstance, the requirement that a president answer a subpoena, would apply not during a criminal trial, as was the case during U.S. v. Nixon, but during a grand jury, as Mueller has impaneled now as well. And also, he wouldn't answer the question of whether or not it would apply to an interview and request for information that way rather than the subpoena of tapes. So he's narrowing the case so much that it wouldn't necessarily apply at all in the Mueller investigation. In fact, he set up the possibility that he would rule that President Trump is immune from the requirement of answering the special prosecutor through his answers in the hearing. And if you had to listen very closely, and you had to basically read his stuff to see how he does this, but it was a very tricky maneuver, I think.
All right, so, you know, to me, look, President Trump got elected because of the Supreme Court. We've had a lot of conversations about that. At the end of the day, yeah, it could be about disruption and, you know, changing the way we do business and attitude and, you know, and throw out the bums and status quo change and all that kind of stuff. But truly, most people who were on the fence thought about the Supreme Court. The Supreme Court was probably as high a priority amongst the electorate in the 2016 election as we've ever seen it. Most folks were worried about Roe v. Wade.
Yeah.
But I'm guessing that Trump at all has much less concern about that. I mean, he does what he does to get elected, but probably has much less concern about that than he does about his own hide.
Yes.
Right? And so these conversations that you're having
That's right.
are probably if there is one, the smoking interpretive gun here, or the interpretive smoking gun in this in this entire review.
Yes, and these statements about U.S. v. Nixon, for instance, were on the record. They were widely reported, and I wouldn't be surprised at all if Donald Trump was shown them. It doesn't mean that he asked directly Kavanaugh these questions, but he would have been shown, this is what this person said about executive power.
Like, this is an ally on the Supreme Court. If you get jammed up, and it comes right down to whether you're compelled to testify or whether you can be criminally charged, this is the guy we want on the court.
And let me say something about your broader point, because really I say this in the book, in the acknowledgments. The book goes back to our original discussions on this show and on your radio show about Trump's antipathy to the Constitution. The oath of office requires a president who is going to subsume his or her own interests to the Constitution. The oath is to preserve, protect, and defend the Constitution of the United States. Trump's instinct is the opposite. It's preserve, protect, and defend himself. And so it's not surprising to me at all that he would look for a Supreme Court justice that would enable that.
Okay. Fascinating. I told you it would be. When we come back, we'll talk about some of the melodrama. I also want to get the professor's thoughts on Rod Rosenstein, who reportedly still, I hope on schedule, has a meeting tomorrow. Stay with us.
I am with Judge Kavanaugh, and I look forward to a vote. And for people to come out of the woodwork from 36 years ago and 30 years ago and never mention it, all of a sudden it happens. In my opinion, it's totally political.
You can't deny that there's a political aspect to this situation. Democrats probably didn't play, altogether fair with the receipt of this letter from Professor Ford, and of course Republicans are really out of protocol with this Senate hearing in terms of what one would expect when charges are being responded to. If it's important enough to respond to a woman's allegations, it seems to me that it's important enough to establish the foundational investigation in order to be able to then interpret it and ask questions. Do you agree?
Yeah, let me say something about the broad approach that I have to this issue. And in the book, there is a chapter about how to nominate and confirm a Supreme Court justice. It's not this way that they're doing it, but I guess I think that we have to have a discussion about what the standard is here. And to me, this isn't a criminal trial. He doesn't have the benefit of the doubt. The burden under Article 1 is on the Congress to decide whether or not this is somebody worthy of a Supreme Court job for life. And the issue is, no one has a right, certainly, to be a Supreme Court justice. And I think if there's a reasonable suspicion that he did these things that he's accused of doing, not beyond a reasonable doubt, but there's a plausible argument for the fact that he did do these things, he absolutely cannot be confirmed. Now, part of that argument is about my concerns about executive power. But I also think that the burden is on him, basically, to show that he has good character and not to suggest that we're going to presume that this person is going to get the position.
Yeah, see, that's fascinating. That's fascinating. I can't wait. So you're seeing this on Wednesday. We're taping this on Tuesday. Corey's going to come on the radio yesterday. So the podcast will be available at 6:30 WPR.com. And the reason I point you to that is I am sure that we'll have a few people on the telephone lines who will be apoplectic over your approach. But it really is easily articulated and well thought out. And that is different standards, different case, different burden of proof. If I had a nickel for everybody on the radio or in my real life who has said to me, "Hey, Dan, what do you think about this?" "Oh, innocent until proven guilty. I guess not anymore." That doesn't apply.
If it was facing criminal charges, absolutely. I'm a big defender of that idea, that there's a strong presumption of innocence, and it's the burden of the government if you're going to put somebody in jail to show that they're guilty. That's not what's going on here. This person wants a lifetime appointment to the arguably most important position on the most important court. He's the 5th justice. And we need to get this right, and we can't assume that he has a right to this job.
And this has nothing to do, well, let me ask you, does this have anything to do with your political philosophy guiding your interpretation of this?
No, I read the Constitution, which certainly does give in the right of the president to nominate a justice, but it places the constitutional obligation in Article 1 on the Congress to give consent to this nominee and to actually make that person a Supreme Court justice. That's an independent role, an independent assessment. And if they thought there were good reasons to not pick him, he wouldn't be in their top 10, for instance, they shouldn't confirm him. We need the best people on the court, not people who are just might be innocent.
So the play here by Professor Ford's lawyers, which failed, they wanted him to speak first and she to speak second. And people are saying, oh yeah, you're the accused, prove a negative, da 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 da. But you're saying none of that stuff applies here. He should be.
I mean, people are trying to apply, exactly as you said, the rules of a criminal trial to what needs to be his burden to show the American people and the Congress that he is worthy of this job. That means that he's got the burden of trying to show that these allegations are completely false, even though they seem, to have credibility.
You know, I have to tell you, in the same sense that after so many conversations that you and I have had, I said, you got to write a book on this.
You did say that. Yeah, you were the first, actually.
And I got a little tickle in the acknowledgments on that, which
Big
is great.
time.
Thank you.
Not a little one.
But now I'm saying to you, you got to get on the national platforms and have this conversation. I don't hear anybody making this analysis, this constitutional analysis. You're on, Morning Joe this morning. Get on all of them and talk about that, because I think it will at least center the citizen's perspective on what this thing is really all about. The drama aside, what the burden of proof here is, or what the goals here are, or what's at stake, and where the balance of need is, right?
Yeah, and let me say, I mean, that's true for this issue, it's true for the other one that we were talking about. There has to be a return to the fundamentals of the Constitution. And so if you want to know if what I'm saying is right, read the Constitution. It says very clearly in the distribution of burdens in Article 1 and 2 that there are two groups that have the burden here of making this decision. One is the president, who nominates a justice, and the other is the obligation to ensure that the Constitution will be protected by somebody of integrity, and that's the role of the Congress.
So tell me, do you think this lack of FBI investigation specifically on this allegation, and at press time, the second charge written about in the New Yorker with the Yale University event had not yet been on the agenda. The senator from Maine is asking for it to be. Regardless, the Republicans won't lay that out. Is there a constitutional argument for an FBI investigation, or is that flexible?
I don't think it's flexible. I think the role of the FBI, for good reason, is to investigate and vet a possible nominee to the Supreme Court, and then to provide information, not only to the president, but also importantly to the Judiciary Committee and the Senate as a whole. It's the Senate, after all, that's got the burden, not the Congress as a whole, of deciding whether or not this nominee is actually going to become a justice. And they need information. That's the role of the FBI in these investigations, is to provide it to them. If they're trying to do it blind, they've abdicated their duty. The Senate has under Article 1.
They would say that they've done some investigation with staff, and that suffices.
Look, as new allegations come up, one of the problems here is the notion of the 11th hour. I don't know how the Republicans, it's a great strategic move, but there's no hour here. There's no time limit. There is a burden on both parties, the president, and a constitutional burden, and on the Senate, to make sure that they appoint somebody who's worthy of the job. They don't want to come back and have to do impeachment years later.
Right. The 11th hour is a product of the midterm election pressure and the idea that they were just about to confirm him. So it feels like an 11th hour, but you're saying is there's no constitutional 11th hour. Just look what happened with Merrick Garland.
That's right. And I think actually it's more than that, that we can't put a time limit on constitutional duty. That when it comes to the obligations of a president, when it comes to Congress, the Constitution is firm about what they have to do, and they can't be rushed into making decisions in violation of that duty.
Any guess on what's going to happen here?
It's hard to know. I mean, I think the nightmare scenario is that the Republicans rush this through, he's confirmed, and then more evidence comes out that there's good evidence that, or at minimum reasonable suspicion or more.
We have one impeachment of a Supreme Court justice?
We had an impeachment very early in the Republic. Justice Chase was impeached but not removed. You need 2/3.
Right.
It's like the process of impeaching and removing a president. So he was impeached in the House. They didn't have the votes to remove him in the Senate. I'd hate to see us have to go through this a second time.
Do you think even the Democrats or the country has the stamina for something like that?
I think we're exhausted when it comes to the institutions being tested. This has been, the past couple of years have been a giant stress test on the United States Constitution, and I don't think we need another one.
But do you think we would if it happened? And the evidence, well, you know what, I guess we'll cross that bridge.
Yeah,
when
I
we
think,
come to it.
yes, I think if it turns out that he's guilty of these crimes and that there's sufficient evidence that comes out after they rush a
Well,
confirmation.
not crimes,
Yeah.
behaviors, because the statute
Possibly.
of limitations has run out on anything that at least has been alleged here.
There's a question in Maryland about whether or not attempted rape, for instance, has a statute of limitations. So it is possible that he could face criminal charges in Maryland.
All right, a quick tidbit on Rod Rosenstein, because he's got a big meeting tomorrow too. Be right back. Okay, so Rod Rosenstein has a meeting tomorrow. Again, we recorded this program Tuesday afternoon, so I'm hoping that, well, not hoping, but I'm guessing that everything is going to be somewhat intact chronologically. A hearing tomorrow, on the Kavanaugh matter and Professor Ford and Rod Rosenstein. So what happens? The president will have a TV thing going on over here. In the meantime, he's going to have Rod Rosenstein in here saying, "All right, hold on a second. What did she say? Oh my God! By the way, did you really say you wanted to wiretap me? Hold on. What did he say? I mean, I don't know what is going to happen
Look,
here. But what's the constitution? Is there a constitutional,
Oh,
practical problem with this meeting in and of itself? Rosenstein is already in somewhat tepid water, continuing to oversee Mueller. Choosing Mueller and overseeing Mueller based on the memo that he wrote that actually had something to do with the removal of Comey. I think he's done the best he could in good faith to navigate the situation, but I only got a minute. What do you think the constitutional issues are, if any, in this meeting?
There is a moment of severe vulnerability of the Constitution right now. When I say a stress test, one place we might fail is if this president is able to fire Rosenstein and replace him with somebody who is able to stop the investigation and do the bidding of the president. The oath of office, as I say in the book and said to you, is all about serving other people, being other regarding, and that would be the opposite. I think it's pretty simple. We need a law, ordinary legislation passed by Congress that would protect the Mueller investigation and protect Mueller from being fired unless there was good cause. That's like the other law, the independent counsel law, that protected Ken Starr and other independent counsels.
So the precedent
and that's
is
what
there.
we need. Absolutely. We had a system that I think we need to bring back. It would be much better to have the protection of independent prosecutor who could investigate a president and not be susceptible, as we now are, to a president who just wants to exercise his or her own power at will.
Yeah, all right. So we got to wrap it now. I only got like 15 seconds. Who's the arbiter of what's constitutional in the big picture, other than you putting on a referee shirt and trying to go in there? Seriously, who's got the stature to do this?
What I say in the book is it's a guide for presidents, but it's also a guide for voters. And the truth is that in the end, it's up to you and me and the American people, the people of Rhode Island, to enforce the Constitution, to read it, and that's why I wrote the book.
All right, when we come back, I'll tell you what's up for the rest of the week. And program note, Corey's back next Friday on a constitutional broad conversation. Stay with us. Corey's point about all of us needing to be better informed. Pick up the book. Amazon, Barnes & Noble, we're all good books. Even the Brown Bookstore, where all good books are sold. I can tell it's a fast read. Do not get flustered by the Constitution being the subject matter. You can breeze through this. It's
written for everyone.
User-friendly. He's still on the show. Written for everyone. Tomorrow night, we're going to repeat our conversation with Joe and Ted on the polling data, since it's debate night on Channel 12. Tune into that at 7 o'clock on Channel 12. See you on the radio at 3. Bye.